Okay, so we will start. Now you can see earlier criminal law that we had, it was Indian Penal Code, right? And now that we have is Bharatiya Nyaya Sanhitha. First of all, like, why did this change? Why was there need for new criminal law, new Bharatiya Nyaya Sanhita? Just see if you can understand the Indian Penal Code, 1860. So just to get hangover, from this colonial hangover and all that, the penal provisions that were given in 1860, it changed over the time. Now, most of you might be knowing about it, but still I'll repeat. The criminal jurisprudence is given to India by Lord Macaulay, Lord Thomas Macaulay. He was a historian and he was a legislator who brought in the criminal laws in India. And moreover, the Britishers, they were ruling over us and they used to think that we Indians are most uncivilized people. So they just wanted to tame us. So the provisions, if you see, if you have all studied IPC, you will feel that the provisions which are given in the IPC, they have relevance, but gradually they are losing on those relevance. For instance, if example I'll just give about unsound mind. That was a time, 1860 or the 19th century, if I say, where the soundness of mind was a taboo. Nobody wanted to reveal it to anybody. And the defense on this was again because nobody wanted to reveal it to the public. They wanted to keep it to themselves. But now if we see this soundness of mind, unsoundness of mind, insanity, lunatic, they all come under mental illness. Disability Act that we have. The definition of unsound mind is taken from there. So you can see the change, the gradual change. Where once this unsoundness of mind was a taboo, and now it is concerned when it comes to the society and it is talked about. Another thing for this change from Indian Penal Code to Bharatiya Nyaya Sanhita was about the modernization and incorporating recent legal developments. I will not say that Indian Penal Code was not amended. There are provisions in Indian Penal Code and approximately 75 times these amendments, the provisions have been amended. Now, when these amendments were done, it was as per the Supreme Court judgment precedents. But then there was a need that there must be a law because it became very haphazard. All the provisions were haphazard. And this BNS being a substantive, all the provisions must be in place. So if we see the modernization and incorporating legal developments, the first and the foremost thing is about gender sensitivity. They have tried to sensitize the gender. It's not he, she, but even the transgender, they have been given, because even as a citizen of India, they have certain rights. So what the new BNS has done, that instead of he and she, all person will be called he. So they have acknowledged this gender as well. So it's not only about a woman or a man, but giving recognition to this gender also. If you see the Indian Penal Code, it uses the term penal, right? Now, what does this penal mean? It is a punishment. Penal means punishment. Punishment for the crime, punishment for the offense. Whereas if you see the Bharatiya Nyaya Sanhita, it talks about Nyaya. Now, Nyaya means justice. So there is a shift from punishment to justice. So you can understand this is more of victim-centric also. Penal was if you have done anything, the convict, he will be penalized. But in Nyaya Sanhita, it is that who has suffered will get the justice. You understand there is a difference between these two terms. So Nyaya Sanhita, the focus or the emphasis is on giving the Nyaya. Rehabilitation. Punishment is not always the answer. Although there are punishments almost, the punishments are like fine, imprisonment, lifetime imprisonment, rigorous imprisonment. But then here they have used, their motive is to rehabilitate the society rather than giving penal punishments to rehabilitate them. Simplification and clarity, which is your next. Yes, about this Supreme Court judgments. 377, 497, they have been repealed. And significant change, even the amendment was done in IPC after the Nirbhaya case. If you remembered Vishakha and the state of Rajasthan, sexual harassment at the workplace, Supreme Court had given the guidelines on it. So most of the time, this provisions, they were the guidelines. But now they have been incorporated in our law. They are very much present in the BNS. Shreya Shinghal case about the freedom of speech and expression. Decriminalization of homosexuality, decriminalization of adultery. And BNS, it emphasizes on why did it decriminalize this is, it says that, it is a subject of personal matter. And the personal matter, it cannot be brought into the criminal proceedings. There is a difference. Something which is very personal to you cannot be brought to the criminal proceedings. Protection of women in live-in relationship. Indra Sharma versus VK Sharma. The non-traditional relationships are getting protection under BNS because of the societal changes. They must be recognized. Puttuswamy versus Union of India case, which is about LGBTQ and rights and privacy. And yes, triple talaq case. So these are the judicial, developments which are also incorporated in our BNS. Simplification and clarity. See, all of you have studied IPC and you must have observed that it's very haphazard. It's not properly, paragraphed, or it's not in a chronological manner. So for the understanding, so that even a layman can understand the BNS, what they have tried is they have tried to keep it simple with the clarity. Now, all the offenses pertaining to woman and child, they are in chapter 5. If you remember earlier, they were spread all over the IPC. But now what they have done for the purpose of simplification, they have kept it under chapter 5. Similarly, the definitions.
Nobody up a log are the.
Kindly mute yourself. Kindly mute yourself. Where was I? So they have, like, for example, definitions. If you remember, the definitions in IPC, it spread into so many sections. But now what they have done here is, for the purpose of simplifying it, they have kept all the definitions under section 2 of chapter 1. Now, if you want to look for the definitions, it's very easy. You just open and see section 2, you'll get all the definitions. Not only this, definitions in IPC, that was the definition which is given, will apply to all the offenses as it is. But here they have kept it open. Open as in, depending on the nature of offense, the definition might change. For example, forgery. Now, when we talk about forgery, we understand it's only the physical document, right? Where the forgery can happen. But if you see in this era of, technology, the forgery can happen in the software. The forgery can happen even in Google Drive and all, the hard disk. So they have given the definition and they have kept it open to include all these kind of forgeries as well. So it's not pertaining only to the physical document forgery. It is open to the definition. It is open as per the interpretation of the court, as per the nature of the offense. Addressing new and emerging crimes. Yes. See, almost for more than 160 years, the IPC was there and we have somehow thrived with it, right? But the emerging crimes, for instance, cybercrime, financial frauds, organized crimes, they needed to be handled. So yes, BNS, we have the provisions, the punishments for the cybercrime, financial fraud, organized crimes. So basically, it has given us more, robust legal response to these contemporary challenges. Address the technological advancements. Now, this definition of technology as given in IT Act. And yes, we all understand this financial fraud, cybercrime. They all are the outcome of this technology. Not only this, now what can happen is a person who is sitting somewhere else, he can abet person in India to commit an offense through this technology. So this needs to be addressed, right? So yes, there is a room for this technological advancement as well. Now, when we talk about rehabilitation, penal to justice, a new concept, a new punishment, I'll say, that has been incorporated, and that is community service. Now, the purpose of community service is about the rehabilitation, so that a person, the offender, the convict, he does not become a regular offender. Chapter 1. Now, if we see the chapter 1, it says, it gives you the preliminary introduction. And as I told you about Section 2, it reads, I'll just read it from the Bare Act so that you can understand. Section 2 says, in this Sanhita, unless the context otherwise requires. Okay, and if I see.
ഞാൻ ഇതൊന്ന് അറ്റൻഡ് ചെയ്യട്ടെ. പുതിയൊരു ആക്ട് വന്നിട്ടുണ്ട്. അപ്പൊ
And in IPC, as I told you about the definition, the same definition will prevail throughout the IPC. But here it is moldable because it says unless the context otherwise requires. So it means that it can be molded. Molded depending on the nature of the offense, depending on the convict, whether he is a first-time offender. So it is open to the judge how he is interpreting it. The definitions have, yes, definitely new definitions have been given. Child, the definition of child is changed. If we go through the IPC, there was no definition as to the child. Child was not defined. Rather, there was the definition of man and woman given, and it said that man is a male human being of any age, and woman is the female of any age. But now in Sanhita, they have given the definition of child, and this definition is any person who is below the age of 18 is child. So be it a boy, be it a girl, if they are below the age of 18, they are child for the purpose of Bharatiya Nyaya Sanhita. Definition pertaining to document. This definition is also incorporated. Now this definition here, if you see, it has given about the figures, the substance by means of letters, figure, marks, but it also includes electronic and digital record. Now here, electronic and digital record, again, if we go to the statement context otherwise requires, they are moldable. Electronic and digital records, it can be changed to the definition to the change. For instance, electronic and digital record, it can be any chip. It can be a hard disk. It can be your, the WhatsApp messages that is exchanged. So that all can be, it comes within the definition of document. Gender, the definition of gender. Now in IPC, the definition of gender, it was pronounced he for male and female. But here, for the purpose of gender sanitization, they have also used the word transgender. Now the transgender will have the same meaning as it is given in Transgender Protection of Rights Act 2019. So you can see the changes that have been brought in, and it's very progressive change. Earlier, the transgender, they could not go to the court, or they do not have this courage, or they do not have this right if any offense is committed against them. But since now we have recognized them in our Sanhita, they have got their rights. Definition of judge. It's again very important. Earlier, the definition of the judge included, quasi-judicial, tribunal, all would come within the definition of judge. Not only this, a judge who is sitting in the court for the purpose of legal proceedings, yes, he is a judge. But if the same person, he is sitting in his drawing room Is he the judge for that moment? No, he's not the judge for that moment, right? So very significantly, it has been said that when he is in empowered by the law in any legal proceedings, criminal and civil, and he has that authority, then only he is a judge. You get it? Suppose, as per IPC, a collector, when he is exercising his jurisdiction in any suit, he was considered as a judge. Member of Panchayat who had this power, even he was, for the purpose of any proceedings, he was also a judge. But now, as per the Sanhita, it is only person who is officially designated as judge, who is empowered by the law in any legal proceedings, a definitive judgment. Then only he is a judge. So that quasi-judicial effect, that has been removed from Sanhita. Another important definition is about movable property. I am just discussing on the important changes that have been brought in and how it's going to affect. Otherwise, all the sections, if you see, they have been taken from IPC as it is, with little changes, as in the punishments have been increased. Okay, full screen mode want. Is it fine now? Okay. So the provisions from IPC has been taken in BNS as well, with little changes as to the contemporary challenges. But then a question might come to your mind. Then in IPC, there were, 23 chapters and 511 sections. But when we talk about BNS, we have only 20 chapters and 358 sections. Then I'll tell you, since the definitions, okay, in IPC, for each definitions, different sections were given. Clear? But in BNS, all the definitions are given under section 2. And there are clauses to section 2 which has all the definitions. Moreover, there are certain sections which have been clubbed together for the purpose of simplifying it. Hence, 511 sections reduced to 358. Yes, there has been a deletion of some sections which have been completely deleted. For example, adultery, it has been completely deleted. Okay, so we'll come gradually to them. Now, movable property. Now, earlier, movable, the corporeal property was the property for the purpose of IPC. But now, in Nyaya Sanhita, they have incorporated even incorporeal properties as well. For instance, demat account, IPR, they all will come under this property now. So the property, the definition or the scope of the movable property, it has also been increased. So it's not only limited to your corporeal property, but yes, it has been included for the incorporeal property as well. Chapter 2, yes. See, earlier, as per IPC, there were only these 5 punishments were given: death, imprisonment for life, rigorous imprisonment, simple imprisonment, forfeiture of property, and fine. In BNS, these all 5 punishments are intact. These 5 punishments are there. Yes, little changes have been made when it comes to the life imprisonment. It has been open for the court to decide whether for a particular offense, the punishment will be life or imprisonment. Now here, if the court does not give the time span, for instance, if the court has not given that the life imprisonment will be for the period of 14 years, then it will be considered that the person has been imprisoned for life for remainder of his life. So for the remainder of his life, he will be imprisoned. So again, this scope, this is given open to the judge, depending on the nature of the offense. And if the punishment is for the imprisonment for life. New punishment, that is community service. Now this is for the purpose of holistic or rehabilitation. The motive is to rehabilitate so that the person does not become a regular offender. Now here, the definition of community service is not given in BNS. Just the mention of community service, or for the purpose of understanding it, it has been given in section 23 of BNS's explanation to section 23. And it says that community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. See, the prisoners who are in prison, if they are doing any work, they are being paid for that work. But then they are imprisoned. Now, for this purpose of community service, they will not be imprisoned. But then they will not be entitled to any remuneration. The motive of community service is not only the rehabilitation, but also the overburdening of the prison has to be reduced. The psychology of the convict, if he is away from his family. You know, at times what happened, the person is arrested, he is in the prison, and say about after a 2 year or 3 year of the proceeding, it comes to the knowledge that the person is not the real person who has done the offense. Then what about the family? The family already suffered, right? And for this purpose, this community service is there. This has been incorporated. Now, this community service has been taken from the US criminology with the intention to reduce the burden on the prison, to see that the family does not suffer, and the rehabilitation of the convict if he is the first-time offender or the offense that he has committed is a very petty offense. For instance, you know, offense which the fine is less than 5,000 rupees. So this community service is for them. Now, again, the extent of this community service is open for the discretion of the court. There is no mention that what will be the community service. So it can be, a person can be asked to plant 100 trees. A person can be asked to keep the surrounding clean. So the nature of the community service, it will depend on the discretion of the court. Now, what petty offenses where the community service can be given as a punishment? I told you about the petty theft. Theft where the price, the value of the object is less than, 5,000. Drinking and shouting, misconduct in public. Non-appearance in response to proclamation by the court. Attempt to commit suicide to compel or restrain exercise of unlawful power. So if a person is restraining any government official from performing his duty, defamation. So these petty offenses are there where the community service can be granted. Now, as I told you, again, it depends on the court. Community service plus fine can also be imposed. And there are, again, the provisions are given. If the person is not able to pay the fine, then what will be the provisions? Commutation of punishment. Commutation of punishment is increasing or reducing the punishment. When there was life imprisonment given to any convict, then owing to his behavior in the prison, he could request the government to reduce his punishment. And on analyzing, the punishment was reduced. On analyzing, yes, the punishment could be reduced. So for the purpose of this commutation of punishment, which was in IPC section 54, 55, 55A, it all has been clubbed into section 5 of BNS. Another thing is in the punishment, the imprisonment, we all are aware that if it's life imprisonment, then it was for the period of 14 years. But now, for the purpose of BNS, it has been increased to 20 years unless otherwise provided, which means it is up to the discretion of the court whether the court is given for imprisonment for 14 years, 16 years, or 20 years. So if the court does not mention the timeline, then it will be considered that the life imprisonment is for whole of his life, the remainder life. Section 8, clause 5. It says that if the offense is punishable with fine of or community service, then the imprisonment with the court imposes in default of the payment of the fine, or if he is not able to perform the community service, then it must be simple fine, or it must be very simple community service. And if in the case he cannot give the fine and he does not perform the community service, even though it's very simple, then he can be imprisoned. Now, this is given under section 8, clause 5. See, the whole provision relating to the community service, it is new to BNS. There was no mention of community services in IPC. But if you see the other statutes that we have, other laws that we have, there were the provisions about this, community service. Not in the sense, not in the exact words of the community service, but then yes, the provisions where the leniency was there. Now, which has been codified in BNS. If a person who cannot give the fine, who cannot perform the community service, then he can be imprisoned. Now, his imprisonment can be not more than 2 months when the amount of the fine is 5,000. In case the imprisonment is for the period of 4 months, then the fine amount will be 10,000 rupees. Chapter 3. Now, chapter 3 is about the general exceptions. the general exceptions, if you in IPC, it was again, very elaborate. Here, the most important thing is about the person of unsound mind. Now, since we have Disabilities Act, mental health, so it's no more a taboo where a person has to hide about his mental illness. Very minor changes actually in general exceptions. Section 41, Clause B, which was earlier Section 103 of IPC, it speaks about the housebreaking. Now it says that housebreaking after night. So there was no clear understanding after night. For the term after night, what would it include? So the change has been done, and it says the definition about after night is after sunset and before sunrise. A very minor changes here and there in general exceptions have been done. But yes, the major focus is on the unsound mind. Because we have different provisions, different statutes. Person with Disabilities Act 2019 amended in 2020, health, mental health care 2016. Now they define the unsoundness of mind. The term lunatic, idiot, they sound very rude. So a better terminology, a better understanding has been incorporated. And in IPC number, if you, in section 89, when it came to the defenses, the term insane is used. So for all these terms throughout the IPC where the insane, lunatic or idiot was used, the person of unsound mind is changed to. Chapter 4, Abatement, or incomplete offense. Rather, abatement, we all understand what is abatement, but then it is incomplete offense because the person might not be directly involved in the offense. Now here comes the territorial effect of BNS. See, a person who has committed any offense within the boundaries of India, he will be convicted in India. Any person of Indian national who has committed, say, murder in Kenya, then he will be, and somehow he has managed to come back to India, then he will be prosecuted in India for the crime that he has done in Kenya. The jurisdiction. But what about a person who is sitting in Kenya, abetting a person in India to commit an offense? The person who has committed the offense in India, he will be penalized, right? He will be prosecuted. But then what about the person who has abetted him? Because he is in some other country. Now, as per the BNS, as per the section 48, any person who abets an offense without and beyond India, he will be prosecuted in India because it will be constituted as if the offense has been committed in India itself. So this is a new provision giving BNS extraterritorial effect. See, earlier, the section 1 of IPC and as well as this BNS, they talk about the territorial jurisdiction of BNS or IPC. But BNS has gone step forward, stating that abating is also an offense. So this abatement is to be prosecuted in India as if the offense was committed in India. Very small change in section 57. Whoever abates the commission of an offense by the public generally or by any number or class of persons exceeding 10, he will be punished with imprisonment of either description for a term which may extend to 7 years and with fine. This punishment earlier was 3 years. So this has been, a minor change has been there in this. Chapter 5. Of offenses against woman and child. Section 63, it defines what is rape. And there are different provisions given what will amount to rape. Now here what has been added is with or without the consent if she is under 15 years of age. See, even in the present BNS, marital rape has not been criminalized. BNS is also silent on this. Also, we all are aware, even in some rural areas of our, country, the child marriage is happening. Even though we have Prohibition of Child Marriage Act, which renders that child marriage is voidable, but it does not render the marriage void. And earlier it said that, not being under the age of 15 years of age. But now this has been increased to 18 years of age, reason being the understanding of consent. Can a child who is below the age of 18 can understand the meaning of consent? What does the term consent means? Whether this consent is under any influence, any misrepresentation, any fraud. So it is presumed, as per the study, the psychological study which has been done, that any person who is 18 and above, they have this understanding what is wrong and what is right. Moreover, 18 is the age when you can cast your vote. So it gives an understanding that when you are casting your vote, you have that sensibility with what is right and what is wrong. You can do the distinction between them. So any child above the age of 18 can understand the meaning of consent, because when it comes to the defense for the rape, the consent plays very important role. Hence, for the purpose of the definition of rape, section 63, subclause 6, it talks about 18 years of age, and exception 2 is also there, which says that sexual intercourse or sexual act by a man with his own wife, the wife not being under 18 years of age, is not rape. Clear? Now, very minor change in section 64, where it talks about the punishment for the commission of rape. Now, after the Nirbhaya case, these laws have become very stringent. Amendment was done in the IPC on these because there were recommendations by the court. And in BNS, they have been incorporated. Now, whoever commits rape, he will be punished with rigorous imprisonment, which shall not be less than 10 years and which may be extended to life imprisonment and can be liable of a fine as well. Section 69. This is totally new provision, although, we have posh guidelines in all the corporates everywhere, in every working place after the Vishakha case. But then, this is penalized, this is given in section 69 of BNS. Now it says that whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same. So deceitful, false promise of marrying, false promise of giving promotion, false promise of employment, or any other pretext, if any deceitful means with the intention to not fulfill the same. Then the person will be punished for the imprisonment, which can extend to 10 years, or such person can be liable to the fine as well. So this is again to accommodate the contemporary challenge of live-in relationship for the sake of promotion if it's happening in any employment. Then yes, the punishment is for the period of 10 years and such person shall be liable for the fine as well. See, the woman and child, this section is very vulnerable section. And that is why the need to protect them. Now, this protection is not pertaining to, see, we are in a society where we call it a patriarchal society, where, a woman was always considered to be under a man, be it a father, be it a brother, be it a husband, be it a son. But now the society has changed. Now there is no more requirement of protection, feminism. Now this feminism, this needs to be protected as well. And this is how the protection can be granted. We have different statutes pertaining to the offenses against women and child. We have POSCO also. But then being recognized and being codified in BNS, it gives it a strong value, a strong meaning to it. Section 228A of IPC, it has been divided into two parts, 71, sorry, 72 and 73. Now, this 72 is about the disclosure of identity of victim in certain offenses. You know, the print or the publishing of the proceedings, the names or the matter, unless and until it is allowed by the court, it will be punished with imprisonment for the 2 year, or the person can be liable to the fine. Because unless and until there's a permission of such court, such proceedings cannot be published, or it cannot be, printed, or it cannot be brought into the public domain unless and until there is the permission from the court. So this was there in the IPC as well under section 228A, but it has been, for the purpose of clarity, it has been now in section 72 and 73 of the BNS. Section 76 and 74. Whoever assaults or uses criminal force to any woman. Now here, gender sensitization. The term earlier was used man. Any man who assaults or uses criminal force on any woman or abets such act with the intention of disrobing or compelling her to be naked shall be punished with imprisonment. Or if he catches or captures the images, voyeurism. So voyeurism was there even in the IPC, where the penal provisions were there. But then gender neutrality that we talk about, this is also incorporated in BNS. So it is now whoever. So it cannot only be a man, it can be a woman. And to give the gender neutrality, the essence of gender neutrality, whoever assaults or uses. Similarly, in section 77, it says whoever watches or captures the images of women will be liable for a punishment of 7 years and shall also be liable for fine. Section 497, after the Joseph Shine versus Union of India 2018, it has been deleted. The sole purpose is the court gave that, or even the BNS emphasizes on this, that personal relationships should not be brought within the purview of the criminology. Unless and until there is involvement of any harm or any violence against the human body. See, the whole system, if you understand, it is based on the damage to the human body. So unless and until it does not bring in any harm to the human body, it cannot be brought within the purview of the criminology. It cannot be brought within the purview of NPS. Hence, the section 497 pertaining to adultery has been deleted. Section 95. This is again a new provision. Okay. Section 79, which is 509 of IPC. Now, just the reading, I'll read the 509, section 509 from IPC, so you will understand the difference. Whoever intending to insult the modesty of any woman utters any word, makes any sound or gesture, or exhibits any object, intending that such word or sound shall be heard or that such gesture or object shall be seen by such woman will be imprisoned with simple imprisonment for a term which can extend to 3 years or the fine. Now here a very small change, but a extent, uh, wide extension has been given. See, the change is in any form. So it's not only the uttering of the word, sound or gesture, but then word, sound, gesture, exhibit any object in any form. Because we are in the era of digitalization. So if there is any electronic medium through which the insult is there to the modesty of the woman, then also the person will be imprisoned. So this is to incorporate the technological advancements. See, these technological advancements, they come with their share of problems. And these problems, they need to be, viewed in the terms of criminology, how they are affecting. The fraud that are happening online, a number of frauds have increased over the time. They do attract the criminal forces. And this statement in any form is an extension to it. It's very wide, actually. It's very wide. It includes electronic and digital medium. So it's not always a publishing any, drawing or publishing anything about the modesty of women, but now it includes all these gesture, sound, exhibit in any form, thereby including the technology as well. Section 494 and 495 of IPC, it has been clubbed to Section 82 of BNS. A new provision that is added, and a very welcoming provision about the child. Now it says that whoever hires, employs, or engages any child to commit an offense will be punished with imprisonment of either description, which shall not be less than 3 years, but it can extend to a period of 10 years with fine. And it will be assumed if the offense has been done. Then the cognizance will be as if the person has committed that offense himself. So, hiring, employing, engaging, or using a child for any sexual exploitation or pornography is covered within the meaning of this section. The children, they are used for the transportation of this, explosives. Now, anyone who has hired them for this, he will be penalized. Again, when it's about the pornography, the technology, the digital medium, the electronic means. So this is a very welcoming provision when it comes to safeguarding the children. Section 96, it is there, it is there even as it is in our IPC, it was there in section 366A. But the term used was man, boy. So now for the purpose and to give the effect to the gender neutrality, the term now is child. Section 98. The term used is child. Okay. This provision of Section 98 was also there in IPC under Section 372. But the child term has been removed and the term minor is used. So in IPC, the term minor was used. So the term minor has been dropped and the term child has been incorporated under Section 98. A very minor change, but then very meaningful change. Because child is as per the definition given under Section 2 of BNS, child is any person below the age of 18. You know, when it comes to the offenses pertaining to the child, they are very specific to the age of the child. Whether such offense is done by a child of 7-year-old, between 8 to 12 and above 12. So it was, age-specific offenses were there, which for the purpose of simplification has been changed to the child is a person below the age of 18. So any person who is below the age of 18, because that created a doubt, who is the minor then? Whom to consider the minor? Very simple to understand, child. So child is any person below the age of 18. Also, it talks about the gender neutrality. It validates gender neutrality. Similarly, Section 99 of the BNS, where the buying of the minor for the purpose of prostitution is a crime, which is given in Section 373 of the IPC. The term minor is removed and child is inserted. So now it is child shall be the 18-year and below. So selling minor for the purpose of prostitution, buying minor for the purpose of prostitution is the crime, is the offense for which the punishment is given, which can extend to 10 years term with fine. And if it's the buying of the minor, then the punishment is 7 years, which can extend to the term of 14 years. See, in BNS, 20 new offenses has been added. 19 provisions that were there in the IPC has been eliminated. And there are more than 33 offenses where the punishment of imprisonment has been increased. This is the lump sum, changes which has been brought in BNS. With keeping in mind the modernization of the society, keeping in mind the advancement, what we call as sustainability, this all has been kept in the mind before making the changes. There was, when this BNS came in, there was, the acceptance is difficult. The purpose was for the, getting the validity for this act. There was no public, consent was given. It was not required. They did not ask for the stakeholders to give their understanding on this. But then it says that the consent or the approval, the consultation with the relevant stakeholders have been taken. If you try to understand the procedure for bringing any such big changes is there should be a consultation with the public. There should be a consultation with the judiciary to before you bring in such changes because it's a huge change. Altogether, a law which was prevalent for more than 160 years has been removed. So there must be some consultation with the public or the judiciary, right? But it says, the legislator says that the consultation with the stakeholders and with the relevant stakeholders have been taken to bring in new IPC. See, I see this change as a very welcoming change, very easy change, although practical application no doubt will be difficult. Till date, the advocates and the lawyers, the IPC was there on fingertip. But now, although BNS is very simplified, BNS is very chronological way it has been maintained, but still it will be difficult when it comes to practice. All the more there, I just went there through this, news where this when this came, no, this were implemented on 1st July, right? So West Bengal Bar Council, they celebrated 1st July as Black Day because they did not accept it, pertaining to the practical difficulties that might come. That was the purpose. So yes, changes have been brought in, but yes, we need to see, we need to uh, check how it is progressing, how beneficial it is, and how it can be, properly implemented. Now, one more thing I'll tell you. See, this act was ready in December 2023, but then it was implemented on 1st July because the very first section of the act itself says that it will be notified when it is to be implemented. Now, any registration of FIR or any proceeding which have started from 1st July will come within the purview of these three new criminal laws. Any proceeding which has begun even on the last day of the June, they will be within the IPC. Because criminal laws, they do not have retrospective effect. Okay, so for today, I have covered from chapter 1 to chapter 5. Tomorrow, I'll cover from chapter 6 to chapter 12. And altogether, there are 20 chapters in BNS. So I plan to complete in these 3 days the BNS for your understanding. And then I will take up BNSS. Okay, that is that which replaced CRPC, the procedural law. Any query, any doubt you want to ask, you can ask now. You can unmute yourself and you can ask.
I have a question, ma'am. So, in 144 section, they say boy importation of boy or a girl from a foreign country, and then here, in 77, they say only about women, and they have defined woman as a person of any age, and again in 144 they are differentiating boy and a girl. So I don't understand if 144 implies to sex 77 or not.
You are talking in reference to BNS?
Yes.
You're saying 77.
Section 77 right now when we discussed
Mhm.
about if you can just go to previous slides.
Whoever watches, right?
Yes. So
This
that is
voyeurism.
again
Okay. And you are talking about 144.
44, yes. So I was just searching for the definition of a woman, and it
Uh-huh.
says female with any age and a man male with any age, and
Correct.
then a child below 18. So it is differentiated
Correct.
over there. But when we see 144
Mhm.
importation of, I think there was something which I was not aware of. But when
It
I was
is
going through,
144, Chanakya,
yeah,
144. It talks about
141.
exploitation.
Sorry, 141, not 144. It was
Okay. Uh-huh.
141. It is one. Whoever imports into Indian from any country outside India any girl, child under the age of 21 or boy under the age of 18, with the intent that a girl or a boy may or knowing to be likely that the age of will be forced to seduce or illicit intercourse with any other person shall be punishable. So
Yes.
here they are defining age, but not the
Yes.
child.
Mm-hmm.
So, how does this get applicable to, or does it get complement to the Section 77?
See, Section 77 says it's about voyeurism, means anybody who is making or watching any woman, okay, engaged in any private act. So it's
Yeah.
altogether different because here the term used is woman. Okay. And
Yes. But when you say because if I'm not wrong, highest number of crime happens. Most of the crime happens. Uh, Not saying any gender specifically, below the child below the age of 80, he may be male or a female. As per my understanding, what I'm going through recent things, because they are highly involved with the new technologies, right? With the new technologies, they have
yes.
more like
Mm-hmm.
this the cyber crimes. Basically, what I'm referring to, our highest number of cyber crimes happens in with respect to the child below the age of 18. So that is the only place. Now the old methods, they are not following the old methods, childs now. They go with the new technologies, like the hacking and everything. They are very well versed with it. So with this coming to the picture, and section 141 still differentiates boy and a girl based on the age criteria. But section 77 says directly about a woman. So what about a child getting imported in India and then getting abuse for
See,
that. Now, yeah. So that is little bit of unclarity what I was not able to understand with this.
yes, yes, I agree, Chanakya. In fact, there will be more such doubts, because it's again, as I told you, it's little difficult to understand the change, to accept it.
Yeah.
Here in 141, if you read the line, it says that whoever,
Mm-hmm.
okay, now this is gender neutral word, whoever
Mm-hmm.
imports into India from any country outside India, any girl and boy. So the references, the age that is given here for the child below 18, okay, it is for the commission of offense. If a child has committed any offense and it is below the age of 18, then what will be the consequences? And if the child is above 18, then what will be the consequences? But here it talks about the importation of a child, importation of a girl and a boy from different country to India. Now, whoever is importing them, he will be punished in India. You,
So here there is a gap of about 4 years for a boy and a child, 18, 19, 20, 21.
no, Chanakya, just try to understand. Okay.
Mm.
Here, the girl under the age of 21 and boy under the age of 18. Okay. Now, they are imported from a different country to India. Now, if they commit any crime in
क्या
India,
चाहिए इसके इसके घर पे दो हैं ऐसे दो हैं इसके पास
if they commit any offense, then how will they be penalized? That is one question. Second question is, they have been imported by whosoever. Now here, who will be, punished? Here, who will be penalized? Here, the person who has imported them, he will be taking the cognizance of the offense will be taken against him, right? It will not be the child. So here, the age is again, I'll not say it's irrelevant, but if it was below the 21 or below the 18, then probably the scenario or the cognizance of offense would be different. The punishment pertaining to that offense will be different. And since they are major, then might be the punishment may be different. So it is for this convenience, probably this distinction is made pertaining to a girl and a boy here. Is it clear, Chanakya?
Yeah, I think I need to go with few case laws to understand this point, because when you combine these two sections, it's little bit tricky to understand, and how to
No,
interpret is
Chanakya,
again a big.
there is no need to combine because they both talk about different offenses. You know, they are two different offenses. So you cannot club these two
Okay,
offenses together.
suppose a person is importing a child from any other country, XYZ country. So
Uh-huh.
that person has to be a citizen. So the boy or a child is not a citizen of India, first of all, because
Okay.
he is imported from any other country.
Uh-huh.
When he attains the citizenship of India, then he is categorized as a child. Till then, he is considered to be the boy and a girl.
No, he is child. He is child for the purpose of as per our Indian Majority Act. He is a major child. But what needs to be understand here is, Chanakya, about the offense. See, we are understanding, we are going through the criminal laws, right? If the importation of such child has happened, first thing is such importation is illegal. Next, what comes is age specific. Now, what is the age? If the age was below the 18, then what will be the consequences? And if the age is above 18, then what will be the consequences? See, consequences will depend on the age of the child. And such child, okay, if he remains in India, as you are saying, and if he commits any crime in India, then obviously he will be prosecuted as per an adult. Because the child, as per the definition, a child is any person below the age of 18. Is it clear, Chanakya?
Okay, yes, ma'am. Thank you.
Because the 77 and 141 which you are clubbing, they are about two offenses. 77, it says what? Whoever watches, captures the image of the woman who is engaged in a private act. So it's totally different. And
Uh,
importation of children is
yes,
totally
ma'am.
different.
Agreed. Agreed. Yes, ma'am. Agreed. We'll see how. What I'm trying to understand is something. Yeah. Yeah, but I take your point about this 77, and so when we club these two crimes, it becomes a completely different. And why only women, not men?
Yes, because women, they are given this whole chapter 5 is on the offenses against women and child.
Okay.
Okay. Moreover, women and child, they are considered as a vulnerable part of the society where they need the protection. Moreover, again, the unchastity of the woman or branding a woman with a different name, these all come under an offense.
Ma'am, I'll tell you very frank thing, not against anyone, but with this, no, women are getting too much powerful. In sitting in Bangalore, city like Bangalore, we are empowerment women, but when you see in different parts of the country, they are misusing it, and
See,
men are losing their actual identity. I have seen it. This is I'm telling you. I have seen
I
it.
I understand. I totally understand. Okay. If I take an example of a posh act itself, okay,
Now
it
it's
talks
gender
about
equal.
any sexual harassment to a woman. But then there are cases where this is being misused.
Yes, but now gender, they are all the corporate companies are following gender equality. They are saying
Exactly.
any employee.
Exactly. So this is what? So this concept of gender neutrality, we are trying to understand it, we are incorporating, but then when it is applied, it will have its share of problems. But then, yes, it will be
Yes.
accepted. Now, see, BNS, when it was, it came into the public domain, there were questions that there won't be the acceptance, how it will be accepted and all. But then now, see, we all are going to accept it. We are going to
We
study it.
don't have option.
That's what.
We
That's
don't have
what.
any option
So
left.
general equality will come like this as well. It will be, a very common phenomena in the coming times. Okay. Any more
Yes, ma'am.
questions? Yes, Geeta? I can't hear you, Geeta.
Can you hear me?
Yes, yes, now I can hear you.
Ma'am, I have one question from community services.
Yes, yes, Geeta.
Yes, it's actually welcoming change. Definitely, I agree. But I have two questions from community services. First is, since this concept has been taken from the US criminology, as you mentioned, ma'am,
Correct.
from the US, yes, criminal law. So when we talk about US society and Indian society, these two are, we have a very different, large, huge difference in these two societies. So how much, ma'am, how much it will be, to what extent it will be possible to, bring into effect this kind of punishments? Because it is a kind of punishment only, community services for petty crimes. So how much it is possible, ma'am, to implement such kind of, crimes in Indian scenario, Indian society? Because I feel this is completely, it's more of a Western, concept, ma'am. It's more possible in Western countries like US and UK. This is my first question. And second question is, ma'am, if anybody has been punished for petty crime for with this community services, who will see that the person is rendering the service? So these two questions I have, ma'am, from this
Correct,
concept.
Geeta. See, your first question is on a practical application.
Yes, ma'am.
How it will be applied, what will it be, how it is going to affect our society. Now, this is again, we need to see ourselves. We need to see how it is progressing.
Because, ma'am, we need a lot of quite a high level of maturity when we talk about and sensibility and responsibility when it comes to community services.
Correct. So, this probably your answer to this question will take time. Reason being, we need to see the examples. Now, this is the law, but then how it is being implemented, we need to see. Okay, because there is no precedent to it. So we need to wait to see the precedent for how it is being implemented. Yes, now as far as who is going to see whether what they are being assigned, whether they are doing it or not, then there will be moderators assigned. Okay, and they will be assigned this duty to see that they are doing their community service. And in case of any failure, as I told you, they will be imprisoned.
Ma'am, who are the moderators, ma'am, in this case?
This will be appointed by the court. The court will appoint them. Suppose if it's for to render the plantation, to plant 100 trees, then probably the court will ask them to go to any forest department to do the service there. So this is how it will be. Okay.
Ma'am, my question is relating to the same thing. Sorry to intervene here. I think we had 5 theories of punishment. So the last one was reformative theory. Now this clearly talks about
Rehabilitation.
anybody serving jail sentence. His behaviors are studied. If he's showing some kind of improvement and realizing the mistake that he has done. So any such thing is clearly under the purview of the jail authorities. They can take a call to put them into community services so that they uh, improve socially, and that could drive some change in their social behavior. When they are back from the serving the sentence, they could live like any other person. So this was already there as the theories of punishment. It was not part of, not explicitly mentioned in IPC. Now with Bharatiya Nyaya Sanhita, I think they have explicitly mentioned it. They have added it.
See, Jagan, the thing is, this community service provision, it's a new provision, okay? And what you are talking about is commutation of punishment, where the punishment can be reduced depending on the behavior of the convict, or it can be
And
increased depending on the nature of the crime he is doing. But
yeah, and
this
by putting them
community
into some
service
kind of
purpose,
social community service,
yes,
that is explicitly mentioned in under reformative theory.
correct. So what I told you, like this motive, this, this concept of this service, it is there in other statutes, but it
Yeah,
was not there in the, previous IPC.
yeah,
But
correct.
they have
Yeah,
incorporated it in BNS.
yeah, yeah.
Because
That
the
was my
BNS,
yeah.
the name itself, if you see, it says Bharatiya Nyaya Sanhita. Now they have become more of the victim centric. They want
Yes,
to give more justice, or to do the justice with the victim also. The motive is
yeah,
this. And that's the reason this community service for them. Now see, if a person is imprisoned and if they are giving their service in the prison, they are being paid for their service, right? But in
correct.
community service, they are not being paid. There is no remuneration associated. But then the grounds will be checked. Like if the offense that is done, if it is a petty offense, as I told you, where the value is less than 5,000, or defamation, or drink and, public nuisance. Because public nuisance at all time is not very offending. It might be under certain circumstances.
The
So
public
again, this
nuisance cannot
analyzing
become
will
a
be done
criminal
by the
offense,
court.
right, ma'am?
Yes.
Public nuisance cannot become a criminal offense.
Yes, that's what. See, earlier, if you have studied CRPC and IPC, you must have studied that public nuisance was considered as an offense.
Yes, it is an offense, but not a.
But
So
yes, but public nuisance pertaining to what? Is it hampering any person? Is it damaging any property? This needs to be
yeah,
taken care, right?
yeah. So only thing is we have to see that any public nuisance caused by a person, whether his offense is cognizable or non-cognizable.
Exactly,
Yeah.
exactly.
So yeah,
On that ground only the this community service will be given. So for
correct.
the purpose of community service, what the court will see is whether the person is first time offender, circumstantial evidences, what were the circumstances under which he had to do it, like road rage we say, right?
Yeah.
Was it intentional? Because the road rage, the accidents that happen, they are most of the time they are not intentional. Nobody intentionally do the accident, right?
It could be. I mean, the general rule of defense that will be applied
Exactly.
here. Yeah.
Exactly. So you cannot punish anybody up. Imagine like this BMW case and all, where a minor is driving. Itself, it's a crime.
Yes. Yeah.
So
Absolutely
that
right.
he is being accused for his part of the crime, because being a minor, how can he was driving? Moreover, he was drunken. And then it committed the death of a
Accident.
person.
Yeah.
But all
Right,
the
ma'am.
road
Yeah.
accidents, they are not. And moreover, if a person, even in the road rage, this road accident, if a death happens, then yes, the person is, he will be given the punishment. But if the person with whom the accident happened, if he takes the person to the nearby hospital who is, injured, he makes the complaint to the police that this accident has happened, then he will not be punished, or his punishment will be very simple, might be
Will
a
be
community
reduced.
service.
Yeah, it will be reduced actually.
Yes.
Hmm.
So all these provisions have been given so that, that's why I'm repeatedly telling you it's victim centric.
Yes, I mean, it has been very detailed now.
Correct. Correct. Okay. Any more questions?
No, thank you, ma'am. Thank you so much.
Okay. And I would just request you to give the feedback so that if there is any room for improvement, I can improve myself. Thank you so much. And looking forward for tomorrow's session also. And tomorrow we will be discussing on chapter 6 to chapter 12. Okay. So I hope you all join tomorrow as well. Thank you so much.
Sure,
Thank you,
ma'am.
ma'am.
Thank you.
Thank you, ma'am.
ma'am.
Thank you, ma'am.
Thank you, ma'am.